What's going on, guys? Welcome to part two of Arrest, a treatise on arrest and false imprisonment. This particular video is going to be about the arrest without a warrant. Okay. If you didn't watch the first one, go ahead and watch that one. If you guys want to get the document, it should be on blacksite32.com on the bottom of the free document section. As always, blacksite32 is where you guys can find out about programs to help you stay in your homes for, whether it's bankruptcy or you're behind on debt, food programs, other services that I provide, discounts, info on me, my seminars coming up talking about court cases and health and YouTube and all that other stuff. Right now, they're only for a VIP. We're just rolling it out, but it will be opened up to other people coming soon. So check back often on blacksite32.com on the seminars page, because we're going to teach you guys how to be successful and how I move and how other people who have been even more successful than me in the private have moved, and they're sharing their stuff with me. So I share it with you. All right. So without further ado, as always, don't forget to hit that bell, like, subscribe. Thank you guys for being loyal, awesome, great people. And hopefully you guys appreciate that, we're not doing anything scammy here or sovereign citizen-y here. I treat you guys with respect. I don't down talk you guys or do anything negative or harsh or whatever else. This is just people having a conversation. Remember, this is also brought to you by a non-belligerent non-combatant who always provides and offers a treaty with the United States. We're just here to do business, so none of this is personal, but it is private. Though we're sharing it on a public platform, so there's that, which is why we're going to be doing seminars once again. So if anybody wants to become part of the Wolf Pack, you can do that by going to YouTube and hitting the join button, or you can send a donation on blacksite32 on there on the donation page. Or if you just want to see what I do when I'm not doing this, then check out my social media page on Blacksite and, add me up on one of those. And by all means, make sure that you guys are not getting scammed. I will never ask you guys for money in your DMs or join some whatever investing group or whatever else. That's not me. If it doesn't come from Blacksite32 and specifically with that exactly spelled email or information, it is not me. Okay, so I just want to put that out there. All right, without further ado, we're gonna jump into the arrest without a warrant section. So let's go.
Nine. 3. Arrest without warrant. The law of the land, the authority to arrest without warrant, was rather limited and well defined at common law. A law which has been made part of our constitutional law in the due process provisions. The common law rule on arrests is based on experience and common sense. As a general rule at common law, an arrest could not be made without a warrant. Thus, the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter, in delivering an opinion for the Supreme Court of Michigan, as follows: "The law governing this case is elementary. Except for a breach of the peace committed in his presence, or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony, a police officer has no authority to arrest without a warrant." 1. The objective in this law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrests had to yield to the liberty of the citizen. The liberty of citizens is too sacred to be left to the arbitrary will of men. I. Cook versus Hastings, 150 Michigan 289, 114 NW 71. 72, 1907. Everyone knows what felonies are. The most common felonies are murder, rape, kidnapping, sodomy, armed robbery, abortion, pedophilia, treason, and arson. A breach of the peace is also obvious and well known. Therefore, everyone's liberty was safe since all knew for what reason they could or could not be arrested. But where is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact? Or if the law on arrests can be changed by statutes? By the Due Process Clause, the common law governs what the law on arrest is in this land, and where it exists the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this matter. 10. State of Minnesota. County of Hennepin. Charles A. Weissman, plaintiff, versus Mark L. Fawning, defendant. 2. Defendant above named.
So now what we're going into are samples of federal district court lawsuits and what information they contain in there for those people who need this information or might be doing this. I believe in this one, they're just talking about the driver's license and whatever else. So I'm gonna let it play. Just want you to understand that this is what it would look like when and if you fill out yours. Plaintiff is going to be you. The defendant is going to have all the parties that are RICO or a part of the deprivation of your rights, as you know, over here. And those are the ones that are going to be summoned. So, all right, we're going to let it play.
Above named. District Court. 4th Judicial District. Court file no underscore 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 underscore. Summons. You are hereby summoned and required to serve upon the plaintiff an answer to the complaint which is herewith served upon you within 20 days after service of this summons upon YOLL, exclusive of the day of such service. If you fail to do S0, judgment by default will be taken against you for the relief requested in the complaint. Dated August 23, 1993. Charles A. Weissman, Plaintiff 11751, West River Hills Drive #I070 Burnsville, Minnesota. State of Minnesota. County of Hennepin. Charles A. Weissman, Plaintiff. Versus Mark L. Fawning, Defendant. Fourth Judicial District. Court file no underscore 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 underscore. Complaint. Plaintiff for his complaint against defendant states and alleges. 1. On September 30, 1992, plaintiff was traveling in his automobile on a public highway called 1-35W, between Richfield and Minneapolis, going northbound when stopped by the defendant acting as a highway patrolman, an employee of the state of Minnesota. 2. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board or commission and is not required to be a licensee. The defendant insisted that plaintiff must have the said license. 3. The defendant then arrested, searched, and handcuffed the plaintiff, without warrant, and over his objections that defendant's acts were in violation of plaintiff's rights and the constitutional provisions of due process of law. 4. The defendant gave no specific charges to the plaintiff, or his being stopped or for the arrest, nor did he advise him his rights, as shown in the defendant's field report, which contained only traffic misdemeanor charges. A copy of this report and an official complaint was received by plaintiff 2 months after the arrest. The defendant brought the plaintiff to the Hennepin County Jail, where the defendant knew that the plaintiff would be subject to booking, which included fingerprinting, photographing, and confinement, or an indefinite period of time, and possibly be subject to other types of assaults and batteries. 6. Further, the plaintiff, by his own admission, made no attempt to bring the defendant before a magistrate or judge, when he had full opportunity to do so, being that the arrest occurred about 10:15 a.m. on a Wednesday. 7. The defendant, acting on his own accord, and without warrant or court order, had the plaintiff's automobile towed to an impound lot, and put it on a hold order.
So, one of the things that we teach, and if you didn't catch that in there, this will be in the seminars too, is that the only time they can kind of get a little leeway, and I mean kind of, because they're always supposed to have a magistrate on duty, okay, that can answer yes, do that, or no, don't do that. The cops have no authority to do these things unless you have done a criminal act. And I don't know about this guy's car, but in general, they're saying even as a normal driver, the police officer does not have the ability, the legal or lawful authority to have the car towed. Now, unless it's in the way, but we all know most of these scum-sucking city working with the police, working with the tow lots, will have your car towed instantly. That's RICO, R-I-C-O. They're working together. They can all be sued. Okay, but when you sue them, you have to sue them specifically on that piece, not the whole thing. Okay, depending on how you set it up. It's one of the reasons why we're going to do some seminars on this. You guys don't have to be rejected and denied your claim and then wondering what happened. You cannot just throw all this stuff together. The magistrate can say, yeah, I think we've got enough there for a crime. Go ahead. I will back you.
Order. 12. Count I. False imprisonment. 8. Plaintiff re-alleges paragraphs 1 through 7. 9. On September 30, 1992, the defendant, without warrant or due process of law, Minnesota Constant, Art. 1, Sector 7, unlawfully arrested the plaintiff, and acting contrary to law, did falsely imprison the plaintiff, depriving him of his liberty. 10. As a result of the defendant's false imprisonment of the plaintiff had his right to liberty violated, suffered mental anguish, a loss of time and wages in his work, and a discredit in his reputation by his failure to attend a scheduled meeting. Count 11. False imprisonment. 11. Plaintiff alleges paragraphs 1 through 7. 12. The defendant, upon arresting plaintiff, brought him to the county jail for the purpose of booking and detaining him, and, by his own admission, made no attempt to bring the plaintiff before a proper judge or court as is required by due process.
Hello.
13. The acts of the defendant in deciding how to deal with the plaintiff after his arrest, and failing to take him to a judge or court to so decide, constitute false imprisonment by the defendant under the law of the land, Minnesota Constant, Art. 1, Sector 2. Count 3. Assault and battery. 14. Plaintiff re-alleges paragraphs 1 through 7. 15. Due to the unlawful acts of the defendant, the plaintiff suffered a series of assaults and batteries upon his person, including arrest, handcuffing, imprisonment, physically searched, forced fingerprinting and booking procedures, and harassment. Therefore, plaintiff demands judgment against defendant, as his liability appears, in the sum of $10,000, $1,000, together with the costs and disbursements. Dated June 24, 1993. Charles A. Weissman, Plaintiff 1175 IW, River Hills Doctor #107D Burnsville, Minnesota. 13. State of Minnesota District Court. County of Hennepin. Charles A. Weisman, Plaintiff. Versus Mark L. Fawning, Defendant. 4th Judicial District. Case number 93-12184. Memorandum of Law on Arrest Without Warrant. Comes now the plaintiff, Charles A. Weisman, a free citizen of the state of Minnesota, who respectfully presents and submits this memorandum as evidence and proof of the prevailing and controlling law regarding the matter now before the court. Arguments and statements of law. The defendant claims that his arrest of the plaintiff without warrant for the violation of 2 traffic laws was lawful. Defendant claims that he is authorized by statute to make arrests for any violation of laws of the state, whether they are a misdemeanor or a felony, when committed in his presence. The facts of this case lead to the conclusion of law that the defendant did not have any lawful authority to arrest the plaintiff. The defendant had no warrant for the arrest of the plaintiff, and he alleges that he only saw plaintiff commit a misdemeanor, i.e., a traffic violation.
Gotcha.
There was no claim of a felony committed or of a breach of peace committed. At common law, and under the provisions of due process of law, such an arrest without a warrant cannot be made. Since the arrest deprived the plaintiff of his liberty by an act not pursuant to due process of law, the arrest is unlawful. Due process is not determined by the legislature.
Sir.
Il is manifest it was not left to the legislative power to exact any process which might be devised. The due process article is a restraint on the legislative as well as on the executive and judicial powers of government, and cannot be so construed as to leave. Page I of 13 Plaintiff's Memorandum on Arrest Without Warrant. 14. Congress free to make any process due process of law, by its veneer will. Murray's Lessee v. Hoboken Imp Company, 18 How. 59 U.S. 272,276, 1855. The Constitution of Minnesota declares that no person shall be deprived of life, liberty or property without due process of law. Minnesota Cons. Art. 1, Sector 7. The words due process do not mean anything which the legislature may see fit to declare to be due process of law. Slate X-ray. V. Billings, 55 Minnesota 466, 474, 1893. Due process was intended to preserve established fundamental rights by requiring that they cannot be deprived except by the established modes of law as existing under the common law. This guarantee that government shall follow a specified and pre-existing rule of conduct, process, or procedure is in itself a right the citizen held at common law, and was claimed by the colonists in early America. Thus, it is clear that the common law is the foundation of that which is designated as due process of law. 6 RCL Cons. Law, Section 435. The Constitution guarantees these pre-existing rights and procedures in the due process provision. What is due process of law may be ascertained by an examination of those sold usages and modes of proceedings existing in the common and staruta law of Inland before the emigration of our ancestors. Twining v. New Jersey, 211 U.S. 78, 100, 1908. The expressions due process of law and law of me land have me same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers, as it existed and was understood and administered when that instrument was framed and adopted. State v. Doheny, 60 Maine 504. 509, 1872. In interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. Eckern v. McGovern, 154 Wisconsin 157, 142 NW 595, 620, 1913. Thus the mode of arrest by which one can be deprived of his liberty is to be determined by the pre-existing common law principles and modes of procedure. A properly constituted warrant of arrest is a process at common law by which persons could lawfully be deprived of their liberty. The common law on arrest without warrant recognized only certain specific and well defined cases whereby a citizen could be deprived of his liberty. This cannot be abrogated or changed by the legislature.
Correct.
The common law drew a distinction between an arrest for misdemeanors, such as that which the defendant arrested the plaintiff upon, and arrests for felonies. When a felony was committed, an arrest could be made without a warrant, but no arrest could be made for a misdemeanor without a warrant unless it constituted a breach of the peace. The misdemeanor traffic violation was not a breach of peace, and thus the defendant needed a warrant to make an arrest for such offense. In determining the law surrounding arrests, the Supreme Court of South Carolina, in the case of Slale v. Byrd, 72 S.104, 51 esse 542, 544, 1905, affirmed a prior disod of the court holding that. Page 2 of 13 Plaintiff's Memorandum on Arrest Without Warrant. At common law, as a general rule, an arrest could not be made without warrant for an offense less than felony, except for a breach of the peace. 3 Sci. 880, State v. Sims. 16 SC 486. 15. The fact that the defendant believed that the plaintiff committed a misdemeanor and had charged him with a violation of the traffic law did not authorize him to arrest the plaintiff. In a New York case, the state Supreme Court held that a city alderman or justice of the peace could not, at common law, arrest or cause an arrest for a misdemeanor not amounting to a breach of the peace, without warrant, though happening in his presence. The Supreme Court, in the case of Badwolf v. Blust, 5 Lansing's Republic 84, 86, 1871, stated, "At common law an arrest could not be made of a person charged with a misdemeanor except on warrant of a magistrate, unless it involved a breach of the peace, in which case the offender might be arrested by any person present at its commission." 1 Chitty, Criminal Law, 15, Carpenter v. Mills. 29 Howe. Proar, 473. In the very well-reasoned and authoritative case of Expart Roads, 202 a la 68, 79 so. 462, 464, 1918, the Supreme Court of Alabama related the due process provision to the Act of Arrests. It asserted that any seizure or arrest of a citizen is not reasonable or due process, merely because a legislature has attempted to authorize it. These phrases are limitations upon the power of the legislature, as well as upon TBAD of the other departments of government, or their officers. In determining what was due process regarding arrests, the court stated, "It must not be forgotten that there can be no arrest without due process of law. An arrest without warrant has never been lawful, except in those cases where the public security requires it, and this has only been recognized in felony, and in breaches of the peace committed in the presence of the officer." Ex Pair Roads. 202 a la 68, 79 so. 462,465, Seiling, Sarah Way's case, 41 Michigan 304, INW 1023, 1879, et al. Also cited and affirmed in Pinkerton v. Verberg. 78 Michigan 573, 44 NW 579, 583, 1889, State v. Williams. 45 Oregon 314, 77 Pac. 965, 969, 1904, Adair v. Williams. 24 Arizona. 422, 210 Pac. 853, 856, 1922. The Alabama Supreme Court in the Rhodes case went on to say that the phrase due process must be determined by what it meant at the common law, and when the Constitution was adopted, page 469. The court then cites the case of Tillman v. Beard. Officers are justified in arresting without warrant only in cases of felony and breaches of the peace. This is elementary. It is needless to cite authorities. At one time in the history of American law and jurisprudence, the concept that no one could be arrested for a misdemeanor except with a proper warrant was so basic and elementary that it was not necessary to give any authorities to prove it. Yet this basic concept was found to be too restrictive to the ever-growing oppressive government that has gained power in this country. Thus, in order for it to control the Page 3 of 13 Plaintiff's Memorandum on Arrest Without Warrant. 16. Liberty of citizens, and to enforce its oppressive laws, the corrupt, de facto government has gradually undermined a very basic principle of constitutional law. In the Pinkerton case, supra, it was held that a police officer could not arrest a woman, without a warrant, upon mere suspicion that she was upon the street for the purpose of prostitution, even under provisions of the city ordinance allowing such arrests. The fact that she bad a reputation of being a streetwalker, and that the officer knew of her reputation and believed she was plying her vocation as such, plus the fact she did not give her name to the officer stating it was none of his business, and that she dared the officer to arrest her, did not give the officer grounds to arrest her. The court said, if persons can be restrained of their liberty and assaulted and imprisoned under such circumstances without complaint or warrant, then there is no limit to the power of a police officer. Any law which would place the keeping and safe conduct of another in the hands of even a conservator of the peace, unless for some breach of the peace committed in his presence, or upon suspicion of felony, would be most oppressive and unjust, and destroy all the rights which our Constitution guarantees. These are which existed long before our Constitution, and we have taken just pride in their maintenance, making them a part of the fundamental law of the land. Pinkerton v. Verberg, 78 Michigan 573.44 NW 579. 582-83, 1889, Larson v. Feenry. 196 Michigan I. 162 NW 275. 276-77, 1917. Under the topic of arrest as found in Volume 2 of Ruling Case Law, we find the heading, Constitutional Requirements as to Warrants, wherein it states fundamental constitutional guarantees of personal liberty protect private individuals in the right of enjoyment of personal freedom without unlawful restraint, and it is universally recognized that no one may be arrested except by due process of law. 2 RCL 463, Section 21. Here again we find that this principle of arrest only by due process of law was once universally recognized, yet the defendant has ignored such process in his arrest of the plaintiff. The law regarding warrantless arrests was also declared by the Supreme Court of Wisconsin in the case of Radloff. National Food Slurs Incorporated, 20 Wisconsin 2D 224, 121 N.W.2D 865. 867, 1963, as follows. In Stitkin v. Rundle. 1898, 99 Wisconsin 7880, 74 NW 536, this court established the principle that an arrest without warrant has never been lawful except in those cases where the public security requires it, and this has only been recognized in felony and in breaches of the peace committed in the presence of the officer. This rule was reaffirmed in Gunderson v. Stubing, 1905, 125 Wisconsin 173, 104 N. W. 149, 1 American Law Reports. Annotated, 585. The Radloff case involved a shoplifter who was stopped and arrested by store employees for taking 2 cartons of cigarettes. The state Supreme Court said that the employees had the right to stop the shoplifter and recover the goods he had stolen from their employer, and were no negligent per se in so doing. However, since the Page 4 of 13 Plaintiff's Memorandum on Arrest 17. Taking of the cigarettes constituted a misdemeanor, the store employees had no right to arrest the shoplifter when they had no warrant to arrest. In the Gunderson case, the court explained that arrests without warrants were allowed at common law only where the ends of justice would be defeated without it, and that it must be confined to cases of strict public necessity. Where a person was arrested without warrant and charged with public drunkenness, which resulted in charges of resisting arrest, it was held by the Supreme Court of North Carolina that the arrest was illegal as the state failed to make a prima facie case by showing that the defendant's conduct at the time of arrest amounted to either an actual or threatened breach of peace. The court said it is manifest that mere drunkenness unaccompanied by language or conduct which creates public disorder amounting to a breach of the peace will not justify arrest without a warrant, and that not every misdemeanor is a breach of THC peace. In a very well-reasoned decision on the subject of arrests, the court held the following. It has always been the general rule of the common law that ordinarily an arrest should not be made without warrant and that, subject to well-defined exceptions, an arrest without warrant is deemed unlawful. 4 by Com 289 et seq. 6 CJS, arrest. 5, page 579. This fecundation principle of the common law, designed and intended to protect the people against the abuses of arbitrary arrests, is of ancient origin. It derives from assurances of Magna Carta and harmonizes with the spirit of our constitutional precepts that the people should be secure in their persons. Nevertheless, to this general rule that no man should be taken into custody of the law without the sanction of a warrant or other judicial authority, the processes of the early English common law, in deference to the requirements of public security, worked out a number of exceptions. These exceptions related in the main to cases involving felonies and suspected felonies and to breaches of the peace, authorities cited. Slate/I, Mobley, 240 NC 476, 83s.e.2d. 100, 102, 1954. The overall opinion of the court stressed the principle of the common law as controlling in arrests, thus characterizing as erroneous the view that any offense in the presence of an officer is arrestable without warrant. In Texas, it was held that an arrest without a warrant for selling in the officer's presence a railroad ticket in violation of a city ordinance prohibiting the selling of such tickets was unlawful, as the offense charged was not a felony, nor an offense against the public peace. MK&T Varia Company via Warner, 19 Texas Civ Tap, 463, 1898. Sheriffs, constables, and other officers under the executive branch of government had always been recognized as having authority to arrest for felonies committed and for misdemeanors amounting to a breach of peace. But this is the extent of their power to arrest without a warrant, and this constitutional principle is well grounded in ancient common law safeguards of individual liberty. Page 5 of 13, Plaintiff's Memorandum on Arrest Without Warrant. 18. In England, under the common law, sheriffs, justices of the peace, coroners, constables, and watchmen were entrusted with special powers as conservators of the peace, with authority to arrest felons and persons reasonably suspected of being felons. Conservators of the peace also had the authority to make arrests without warrants in case of a misdemeanor which involved a breach of the peace committed in the presence of the officer making the arrest. 2 Ruling Case Law, page 446, Orrick v. State. 105 So. 465, 469, Mississippi, 1925, Graham v. Stair, 143 Ga 440, 85 C 328, 330, 1915, Kennedy v. Seor, 139 Mississippi 579, 104 So. 449, 450, 1925, Wilson v. Town O.J. Mooresville, 222 NC 283, 22s.w.2d 907. It has been held that constitutional provisions of rights are to be interpreted according to the common and statute law of England prior to the emigration of our ancestors, and by the law established here before the Constitution was adopted. Under the common law, the powers of state agents were limited and the requirements for an arrest warrant was strictly enforced. United States v. Tarlowski, 305 F. Sup. 112, 116, 1969. This procedure for arrest is part of the due process of law provision of the Constitution, which protects citizens from the arbitrary infringement of their right to personal liberty. Thus, any specific authority for arrests must be based upon the common law procedures that allowed a deprivation of one's liberty. This was so held by the Supreme Court of Michigan as follows. It has already been decided that no arrest can be lawfully made without warrant, except in the cases X is tine at common law before our Constitution was adopted. People v. Swift, 59 Michigan 529, 26 NW 694, 698, 1886. Since liberty cannot be deprived except by the law of the land or due process of law, no statute or ordinance can constitutionally be enacted which allows arrests without a warrant for any purpose the legislature decides. Due process is a limitation upon the legislature, and thus a legislative statute cannot be the due process by which one can be deprived of his liberty by arrests. In a legal article titled, Arrest with and Without a Warrant, written in the University of Pennsylvania Law Review, Volume 75, Number 6, April, 1927, page 485, numerous authorities were cited in support of the following proposition. It is usually said that not even a peace officer is privileged to make an arrest without a warrant for a misdemeanor which does not amount to a breach of the peace, and there are many cases which expressly deny the privilege to arrest for such a misdemeanor. P. 486. In the annotation of To Be American Law Reports, Volume 1, page 585, is found a legal study titled, Constitutionality of Statute or Ordinance Authorizing an Arrest Without a Warrant, in which the following is stated. 11 has been stated that in cases less than a felony an arrest could only be made without warrant, where there was a breach of peace in the presence of the person arresting, cases cited. Page 6 of 13 Plaintiff's Memorandum on Arrest Without Warrant. The limits to the power of arrest by a constable, without process, was well defined at common law. To prevent the escape of a felon, he had authority to arrest anyone whom he reasonably suspected to have been engaged in the perpetration of a felony. To prevent breaches of the peace, he had the right to arrest any person who was engaged in, or in his presence threatened to engage in, an affray or other breach of the peace. Beyond this, the law did not allow him to exercise the function of determining whether there was a sufficient case of the violation of a law to justify an arrest. Reed, J., in Newark v. Murphy, 1878, 40 NLL 145. 19. After this excerpt, the law report stated that the foregoing statement from Newark v. Murphy is in accord with the weight of American opinion. Those cases which seem to deviate from this proposition are those which have upheld arrests for certain acts that were unlawful at common law, such as streetwalkers. In Tiedemann's Treatise on the Limitations of Police Power, 1886, Section 33, is found the requirements for a lawful arrest and the exceptions to a warrantless arrest. 33. What constitutes a lawful arrest? As a general proposition, no one can make a lawful arrest for a crime, except an officer who has a warrant issued by a court or magistrate having the competent authority. 33a. Arrests without a warrant. Although it is the general rule of law that there can be no arrest without a warrant of the nature just described, yet there are cases in which the requirement of a warrant would so obstruct the effectual enforcement of the laws that the ends of justice would be defeated. For public reasons, therefore, in a few cases the personal security of the citizen is subjected to the further liability of being arrested by a police officer or private individual without warrant. But the right thus to arrest without a warrant must be confined to the cases of strict public necessity. The cases are few in number, and may be stated as follows. L. When a felony is being committed, an arrest may be made with home warrant to prevent any further violation of the law. 2. When the felony has been committed, and the officer or private individual is justified, by the facts within his knowledge, in believing that the person arrested has committed the crime. 3. All breaches of the peace, in assaults and batteries, affrays, rims, etc., for the purpose of restoring order immediately. The rule of the common law, that a peace officer or a private citizen may arrest a felon without a warrant, or on view a breach of the peace, has never been extended to any and all misdemeanors. While there have been some erroneous decisions that have recognized statutes authorizing arrests for misdemeanors that do not constitute a breach of the peace, none are based upon the meaning of due process of law. Thus, arrests are not lawful where only a misdemeanor occurs unless it is of the nature of a breach of peace. At the common law, an officer had no authority to make an arrest for a misdemeanor though committed in his presence unless it involved a breach of the peace. The Page 7 of 13 Plaintiff's Memorandum on Arrest without Warrant. 20. Right of personal liberty is a very high prerogative right, and to deprive one of that right without due process clause, we must find specific authority for doing so. It cannot be left to inference or some strained construction of statute or ordinance. Ordinance. State v. Lutz, 85W.VA. That law permitted an officer to arrest without a warrant on reasonable suspicion based on his knowledge that a felony had been committed, in all other cases, except in the case of a misdemeanor amounting to a breach of the peace committed in his presence, an officer had no authority, at common law, to arrest without a warrant. Authorities cited, Kaminsky v. Durand. 64 R.J. 387, 12 Atlanta 2D 652, 654, 1940. In American Jurisprudence, 2D, Volume 5, under the subject of arrest, Sections 26 and 28, pages 716, 718, it states: At common law, a peace officer cannot arrest without warrant for a misdemeanor, although committed in his presence, unless a breach of peace is involved. At common law, the right to arrest for a misdemeanor committed in the presence of the officer is limited to those offenses which amount to a breach of the peace. The basis for the rule is that arrest without warrant is permitted, in cases less than felony. Not for the apprehension of the offender, but only for the immediate preservation of the public peace, and, accordingly, when the public peace is not menaced, a warrant is necessary. Authorities cited, see also Section 22. In Corpus Juris Secundum, Volume 6A, under the subject of arrest, and under the heading of Arrest or Detention without Warrant, Section 10, page 17, it is written: At common law, however, it has always been the rule that, except in cases where the public security has demanded it, arrest without a warrant is deemed to be unlawful. Due process of law, which declares that no citizen shall be deprived of any of his rights of life, liberty, or property, unless by the law of the land or the judgment of his peers, Minnesota Canst, Art. I, Sector 2 and 7, is the controlling factor in the matter of the arrest made by the defendant. An arrest is a deprivation of one's liberty, and the due process that must be followed in an arrest is that process which existed at common law. To prevent the exercise of arbitrary power at the discretion of government, it was deemed wise to secure the principles already sold in the common law upon this vital point of civil liberty in written constitutions. Cooley, Constable Lim, 364 and notes. Page 8 of 13 Plaintiff's Memorandum on Arrest without Warrant. 21. Where a Chicago policeman arrested a man for vagrancy, the officer was found guilty by a jury of false imprisonment. The Supreme Court of Illinois upheld the conviction of the policeman and declared the rule of law regarding arrests without warrants. Blackstone says, the constable hath great original and inherent authority with regard to arrests. He may without warrant, arrest anyone for a breach of the peace committed in his view, and carry him before a justice of the peace, and in case of felony actually committed, or a dangerous wounding whereby felony is likely to ensue, he may, upon probable suspicion, arrest the felon, and, for that purpose, is authorized, as upon a justice's warrant, to break open doors, and even to kill the felon, if he cannot otherwise be taken. 4 by Conan. 292. In all other cases, however, the authorities are uniform. A constable or policeman has no authority to make an arrest without a warrant. Amhorides cited, Shanley v. Wells. Shanley v. Wells.
So that's the part, guys, that these police officers don't understand, is that each time they're out there without a warrant and they arrest somebody, put somebody in cuffs, take them down, they can be held liable. Now, if you're doing something illegal, endangering the public safety, criminal, or a misdemeanor that endangers public safety, then they can do it. Other than that, they can't. They are liable for so many things. That's why you should have your UCC done. You should have your fee schedule, and that's when you can go to town. I'm not saying this so that you guys can go out and do stupid stuff, or think you're above the law, or purposefully do some things to try to have a court case. You can try to sue them to get some money. Not at all, because if they find that you've done these things on purpose, they will come after you with everything. Everything. And they will make an example out of you. And you do not want to be on the business end of that machine. But if you are legitimately trying to live privately and they're doing these things, you have remedy. But let's keep going.
Shanley v. Wells. 71-111. 78-82, 1873. In a case for false imprisonment, the Supreme Court of Maine examined the law regarding arrests and held, the principles which, by the common law, regulate the right to arrest, or cause an arrest, without warrant, have been long settled both in this country and England, and, by these principles, the rights of these parties must be determined. After citing numerous cases involving the authority to arrest, the court stated, in many of these cases it seems to have been held that the authority of an officer to arrest for misdemeanor, without warrant, is limited to breaches of the peace or affrays, committed in his presence. Palmer v. Maine Cent R. Company, 42 Atlanta 800, 803, 92 me. 399, 1899. In a case involving a state liquor prohibition law, a man, while walking down along a public street, was accosted by a police officer, and asked if he had any liquor on his person. He replied that he did. Thereupon the officer searched him and found a pint bottle of liquor in his inside coat pocket.
So right there, you have to understand that they can ask, but these people are not your friends. No offense to the good officers out there. This is just information that can be used. But you do not have to answer that question unless he says, I think I just got a report that you stole this and you committed a crime. But in this particular situation, he didn't say he thinks you did a crime. And though he could go after him for possibly being publicly intoxicated, depending on the man's level, and if he's endangering himself or other people. So you'd have to know a little bit more about it. But anyway, let's go on.
Pocket. He was then taken to the police station. The State Supreme Court of Wisconsin said that when the police office stopped the man, he was illegally arrested and was illegally searched, as he had due warrant to do either. The
Facts.
court said that it is a serious thing to arrest a citizen, and it is a more serious thing to search his person, and it must be done in conformity to the laws of the land.
Would be
Regarding the
Wisconsin.
law on arrests, it held at common law, arrests for misdemeanors were not permissible without a warrant except for acts committed in the presence of the officer causing a breach of the peace. Peace. Allen vs. Thus, in order that the citizen's sacred right of liberty be secure and preserved, it has always been fundamental law that arrests without warrant were not deemed lawful, with only a few well-established exceptions of felonies and breaches of peace. The liberty of citizens would never be safe if such principles could be determined, and thus. Page
Facts.
9 of 13, Plaintiff's Memorandum on Arrest Without Warrant. 22. Abrogated by statute. Therefore, these principles surrounding arrests are regarded as fundamental law under our American system of government, as held by the Supreme Court of Michigan. Under OUF system, we have repeatedly decided, in accordance with constitutional principles as construed everywhere, no arrest can be made without warrant except in cases of felony. OC in cases of breaches of the peace combined in the presence of the arresting officer. This exception, in cases of breaches of the peace, has only been allowed by reason of the immediate danger to the safety of the community against crimes of violence. Yerkes v. Smith, 157 Michigan 557. 122 NW 223, 224, 1909, citing Robison v. Minor. 68 Michigan 549.557-58. 37 NW 21. 25, 1888. In the Yerkes case, it was held that the playing of baseball on Sunday did not necessarily involve a breach of peace justifying an arrest, though it may cause a breach of peace. The court said that before a summary arrest can be made for a breach of the peace, not only must OVRT acts be committed in the presence of the officer, but they must be violent and dangerous acts of some sort. In the Robison case, the court held that a liquor law ordinance which allowed arrests without process was unconstitutional because it was not pursuant to due process of law. Where a man was arrested for public drunkenness, the question arose whether this was an offense for which one could be arrested without a warrant. The Supreme Court of Appeals of Virginia declared the law on arrests common law to arrest is the law on that subject in Virginia. At common law, a peace officer may arrest without a warrant for a breach of the peace committed in his presence, but for no other misdemeanor. Gallagher v. Commonwealth, 161 Virginia. 1014, 170 SE 734, 736, 1933. Authorities cited. The common law ON arrest is the same in every state, as due process of law has the same meaning throughout America. The security of the citizen's liberty in this country is to be more highly regarded than it was in England under the common law. To say it is less regarded is to make a mockery of the Revolution. In a New Jersey case, a man was arrested by 2 city policemen on orders of their superior to do so, alleging that he was guilty of disorderly conduct, and was taken to a police station and held overnight. This was done without any charge or complaint made against the man and without any warrant. The ONLY authority for the arrest was that the officers were told to do so. In a suit for false imprisonment, it was held by the Supreme Court of New Jersey that the arrest was without authority and gave the following opinion. The legal principle underlying this case and the one to be applied to Lee Fackles is firmly embodied in the ROOLS of the common law, which has been handed down to us from early times unimpaired, in its full vigor, for the protection of personal liberty against illegal arrests. The liberty of the person is too important a matter to the state to be interfered with without the safeguards with which the law guards such invasions. This court has. Page 10 of 13 Plaintiff's Memorandum on Arrest Without Warrant. Said, the limits to the power of arrest by a constable, without process, was well defined at common law. The regard for liberty of the person was so great that the common law did not confer upon a mere conservator of the peace the power to touch the person of the subject, of his own volition, except in those cases when the interests of the public absolutely demanded it. Collins v. Cody, 95 N.1. Law 65, 113 Atlanta 709, 710, I 920. 23. Said, the limits to the power of arrest by a constable, without process, was well defined at common law. The regard for liberty of the person was so great that the common law did not confer upon a mere conservator of the peace the power to touch the person of the subject, of his own volition, except in those cases when the interests of the public absolutely demanded it. Collins v. Cody, 95 N.1. Law 65, 113 Atlanta 709, 710, I 920. 23. In a Pennsylvania case, a woman was arrested for causing and procuring to be made loud and annoying sounds and noises at late hours of the night, in a certain
Hello.
tent near a city street, by beating upon a drum.
Oh, okay.
Upon indictment, her counsel moved that the indictment be quashed as she was arrested without affidavit and warrant while she was in a tent upon private property. It was held that the arrest was unlawful as the act was such that summary arrest was not justified and due process required a warrant for such arrest. It is the undoubted right of every person in this community not to be deprived of liberty without due process of law, and if the defendant has been arrested without due process of law, the indictment against her cannot be sustained. It has long been recognized that arrests without warrant are justified in cases of treason, felony, or breach of the peace, in which actual or threatened violence is an essential element. I Hales P.C. 589, 2 Hawkins P.C., ch 13, Sector 8, 1 Burns, 1, 287, for Blackstone, 292, 9 Bacon, Abrid. 468, 1 Chitty Cr. Law. 15, Clark's Criminal Procedure, 39, Russell, Crimes, Volume 3, page 83, for America and ENG. It must be remembered that not every misdemeanor involves a breach of the peace. Commonwealth v. Gorman, 192 NE 618, 620. Under the common law, acts that were malum per se, that is wrong or unlawful by their nature, were often felonies or breaches of the peace, and subject to arrest without warrant. But that is not the law for an act that was only malum prohibitum, being made unlawful only by statute.
Okay, so what did they say? Malum prohibitum. Latin. It means unlawful by statute. Okay, so malum is unlawful. Prohibitum is prohibition or prohibited. Okay, so made prohibited by statute. All right. And without such an enactment were otherwise innocent acts, which means the states do not have the right to abrogate or abridge your rights, meaning they cannot step over your constitutional protections, rights, liberties, and freedoms because of their statutes. The states themselves are private member groups, associations. They are not final law. When they decided to give up some of their sovereignty and join together in this union, they gave up full sovereignty. So they are not the final law. They are legal, a corporation, for profit, doing government things, but government within their own right. No different than the Boy Scouts have their laws, Masons have their laws, the Shriners or the I'm trying to think of some other groups here. Golf courses, they all have their own internal things. They are God there, but they still yet, none of them, unless all considered completely private, can deprive you of things. And if they're doing something to you so heinous within those private things or public, then the government can say, yeah, we're not having that. So let's move on, shall we?
Statute, and without such enactment were otherwise innocent acts. The law asserts that for such statutory misdemeanors, not amounting to a breach of the peace, there is no authority 3 an officer to arrest without a warrant. As a general principle, no person can be arrested or taken into custody without warrant.
Boom
But if a
shakalaka.
felony or a breach of the peace has, in fact, been committed by the person arrested, the arrest may be justified. Justified. Burns v. Urban, 40 N.Y. 463, 466. No person shall be deprived of life, liberty, or property without. As a general principle, no person shall be deprived of life, liberty, or property without due process of law.
All right, so the part that skipped over here for whatever reason, it does happen. These things don't get them perfect all the time. It says, while the search and seizure provision of the Constitution regulates the manner in which warrants can be issued, it is the due process clause, gem drop, which protects citizens from unlawful arrest without warrants.
Law. And, under like restrictions in the Constitution, it has been held in some states that arrests shall not be made without warrant, except for felonies, and for breaches of the peace committed in the presence of the officer arresting. North v. People, 139 ill 81, 28 Ni 966, 972, 1891. Page 2 of 13 Plaintiff's Memorandum on Arrest Without Warrant. 24. Thus, where an arrest is made without warrant, in a case not involving a felony or breach of peace, the arrest is unlawful. Arrest without warrant where a warrant is required is not due process of law. An arbitrary or despotic power no man possesses under OUF system of government. Thus when a police officer exceeds his powers in making an arrest he becomes a trespasser and is liable for false imprisonment. Musco v. Commonwealth, 86 Virginia 443, 10 C 534, 536. For other authorities on this matter see 1 A.M. Law Republic, Anno, 585, et. Seek, Com va Carey, 12 Cusb. 246, Massachusetts, 1853, 6 ACJ.S, Arrest Section 10, page 17, IMPRISONEMENT, A Treatise on the Law of Sheriffs, Volume 1, Section 166, 1941, Hill v. Day, 168 Kansas 604, 215p.2d 219, Lee v. State, 45 Texas CR, R. 94, 74 SW 28, 1903, 22 Michigan Law Review 673, 703 to 707, Ulfstad v. Dolphin, 278p, 681, 684, Wash. 1929, in Kellum, 55 Kansas 700, 41p, 960, 906. Conclusions. It is a maxim of law that liberty is more favored than all things. Dig. 50, 17, 122. Thus the law favors liberty above all things and applies the most liberal interpretation to it. The common law rule regarding the procedure and process for arrest was established in IHE's country. In Aller v. Wayne Company, 43 Michigan 76, 97, 4N, W, 492, 495 to 96, 1880, Mr. Justice Campbell says, the Constitution has also provided that no one shall be deprived of liberty without due process of law, and has provided that no warrant shall issue except upon oath or affirmation establishing probable cause. It has been settled for centuries, and the doctrine has been recognized here, that except in cases of reasonable belief of treason or felony, or breach of the peace committed in presence of an officer, there is no due process of law without a warrant issued by a court or magistrate upon a proper showing or finding. It is thus fundamental that the Due Process Clause of the Constitution protects the citizen from unlawful arrests. State v. Quinn, 97 C 62, 64, SC 1918.
You hear them say like 1918, that the year, that's literally the year this was already decided. This has been law since 1918, this part of it. In this particular court case, now called an opinion, okay, depending on, well, it should be in the, Constitution here. 1918 was when this was already made into law. So this is what they mean when they talk about case law. So if you have the same scenario going on, for the most part, they will rule in the same favor, but it's already been settled. All right.
1918. By the common law, which is that law due process guarantees, a citizen cannot be summarily arrested when he is found violating a law that is only a misdemeanor. A warrant must first be acquired to arrest such a person pursuant to due process of law. If that which constitutes due process of law is made to depend upon the will of the legislature as expressed in a statute or charter, then no fundamental principles of law or rights are perpetuated or secured against abrogation. Page 12 of 13 Plaintiff's Memorandum on Arrest Without Warrant. 25. An arrest is a deprivation of one's liberty.
It means to say, which is true, it's a deprivation of your rights under 241 and 242. So you're being deprived of your rights, and you're being deprived of your rights under color of law. Okay. If you don't know what those are, watch my other videos, or like I said, book a session in the seminar or consultation. We go into this a little bit deeper, but let's keep going.
Liberty. The state constitution requires that no person shall be deprived of life, liberty, or property without due process of law. Minnesota Constable Art. I, Sector 7. The procedure for arrest under TB common law is what constitutes due process today, as the Minnesota Supreme Court held. What is due process of law is usually a traditional or historical question. Was it due process of law under the common law, and did it remain such up to the time of adopting the Constitution? CN. The foregoing proves that an arrest is a deprivation of one's liberty. Liberty. The state constitution requires.
Okay, let's try to skip a spot. So it goes on to say, the law is very jealous of the liberty of the citizen. Do you hear that? And they're talking about on the state level. The law is very jealous of the liberty of the citizen because we overstand the law. Man created that law. Ultimate law is God's law, natural law. Then there's man's law. So the law is jealous of the freedoms of the state citizen, the citizen of the United States, the national, because it cannot do what we do. These corporations do not have the same power we do. What they've done is they've turned us all into corporations with the all capital name. In Black Law's dictionary, this is capitis demutio maxima. In the U.C.C., this is 1-201, section H, under definitions, conspicuous format, the use of the straw man or all capitalized name, which is a contractual, corporate, official, commercial thing. Where the offense is less serious, the greater the formality prescribed of the exercise of the power which can deprive the citizen of his liberty, Porter versus State. The citizen cannot be summarily deprived of his liberty because of his infraction of some ordinance or statute, unless at common law he was liable to arrest. So your statutes and codes do not apply unless I'm disturbing the peace. It's a misdemeanor where I'm disturbing the peace, or it's a criminal act. Everything else is is not an offense where I can be deprived of my liberty. The misdemeanor traffic statute involved in this case is such that it does not allow the defendant to arrest the plaintiff without the formality of a warrant. Therefore, and there's a little bit more to this part too, and I think we cover it and later in the other video. So after this, there should be another video popping up where you can watch the next one. I will also create a video where it's all just a straight run through of information where we're just going to have them talk through the whole thing. It says, therefore, the defendant is guilty. Police officer, the law officer, hell, even the sheriff, depending on what he's doing, who's supposed to be constitutional, is guilty of false imprisonment for arresting the plaintiff without authority of law. The foregoing proves that the common law surrounding the arrest was always recognized in this country and is thus a requirement for the due process in depriving the plaintiff of his liberty. It is the law of the land. Okay, this right here, I'm gonna throw you guys out a little gem. Terra firma jurisdiction. Okay, it's a gem drop if you know what to do with it. As such, these principles are constitutional mandates and cannot be abrogated or abridged by their mere statutes. Respectfully submitted and stated, juris a de jure. Okay, jurisdiction is de jure by Charles A. Wiseman. Okay, the next one we're going to cover is breach of peace and felony arrests. So that is it for now. You guys are caught up. I'm going to take a break for the day. It's time to grab some din. Thank you guys for watching the videos. If you guys want to learn more, watch more videos. Before hitting me up, make sure that you guys watch the videos. Hit Black Site 32. Watch the videos. All right. But if you need to, yes, we can do a consultation. If you're going to do that, read through all the options. And then from there, if you need it, we'll do it. And if you're not sure if it's something I may or may not know, email me beforehand and I'll give you the heads up if it's something I can do or won't do. Otherwise, there are multiple options, including now giving a basic educational overview of your particular case. And for the love of God, if you're going to do this privately and educational purpose only, I'm not responsible for your outcomes or any actions or inactions, et cetera, et cetera. But keep it real, be honest, and I do not do overviews where people have been hurt or children, any forms of person on whoever abuse. I don't do any of those things, so don't bother trying. I will return and refund your money and close that down, cancel it immediately. I do not do those things. Not what I'm here for. Sorry, that's just a personal thing for me. I'm not a lawyer, an attorney, or a liar, so I don't have that's you're gonna have to pay somebody who can deal with that on their own soul, because if you've done those things, you hurt somebody or a kid or whatever else, um, that's not my ballpark, not my ball game. So, but if it's something where it's like nobody's been hurt, maybe some minor damage or whatever else, yes, we can take a look at those things, or certain infractions or whatever else. Where your rights were violated, that's more where I specialize in. So with that being said, guys, once again, hit that bell and subscribe. Thank you for everything you guys have done, and I will continue to bring you guys fire information because we have so much more stuff to cover, and I'll bring it to you hot and ready. All right. So have a good one. Wolf's out.